Hello, good evening, folks. You're tuned into Capital Radio, and welcome to my show, Let's Litigate with Elvis. This is a show where I'll be giving you a legal spin on various issues and presenting the law in a fun, simple, and straightforward manner to educate you, yet also entertaining you at the same time. So, as always, I encourage you to express your opinion on the topics discussed. You can simply do so by sending a WhatsApp voice note to 065 I repeat that number, 065 And the views expressed on this show are not those of Capital Radio, as the show is purely for informative purposes. Tonight we'll be talking about eviction. Under what circumstances can your landlord start evicting you? Is your landlord legally permitted to turn off the water and lights if you're behind on your rent? And what about the deposit that you pay? Where does the law say this money should go? All these are questions that people need answers to, especially if you don't have the privilege of owning your own property and you're renting. And with the way the economy is, along with the high levels of unemployment, the fear of every tenant is finding themselves unemployed and being unable to pay their rent. Because in such circumstances, you never know what the landlord may do. And we often hear horror stories of tenants being forcibly and illegally removed from the property that they're renting, or their property being taken out and the locks getting changed. But what does the law say? Before we get to that, as usual, I'll start the show with the light-hearted segment that I like to call Hot Topics. What's happening in the legal field in South Africa and around the world? And tonight on my Hot Talk panel, I have three guests, two of whom are also in the legal field, and one that is in the field of psychology. So we have Altaf Raouf and Ashley Naika. They're both candidate attorneys. Joining us as well is Janelle Gibson. She's an educational psychologist, and she specializes in psychoeducational assessments and psychotherapy, working mostly with children and adolescents. Good evening, Janelle, and welcome to Hot Topics.
Good evening, Elvis. Thanks so much for inviting me on the Hot Talk panel tonight.
All right, we also have Altaf. Hello, Altaf. Welcome to Hot Topics.
Good evening, Elvis. Thanks for inviting me to the Hot Topics tonight.
All right, and last but not least, we have Ashley Naika. Ashley, how are you doing tonight?
Good evening, Elvis. Thank you for inviting me on the Hot Talk panel tonight.
All right, in this social media age, whereby just the click of a finger, you can express your thoughts, feelings, and ideas to literally hundreds upon thousands of people, have we lost the power to discern what is private and should be dealt with privately versus what is worthy of commentary from society? Have we de facto become slaves to social media? What do you think? I mean, we have celebrities and ordinary people alike posting everything, like what they're having for dinner, to intimate information that should remain private. Like, for example, there was a video doing the rounds on social media of a famous local presenter whose wife recorded him admitting to infecting her with an STD. One wonders, was it really necessary to post that to the world? Wasn't that something that should have been dealt with privately? So why do we feel the need to just post everything? Is this healthy? Janelle, I'll start with you. You're a psychologist. What are your thoughts? Have we become slaves to social media? And why do we feel the need to have social media validation?
Elvis, regarding the need for social media and the need to be validated, I think it's a major issue in our society. You know, people only post pictures that are the best pictures, that have been photo edited, that have the best filters. We don't post how our real lives are, how we're constantly so stressed, how we sometimes feel like we're on autopilot. Instead, we're posting the best because we want to get the most likes, we want to get the most comments. So I really think that we almost have developed an addiction to social media and an addiction to the recognition of others, and we no longer search ourselves for value and for what we want to be. So our self-worth is now defined by other people.
You know, I totally agree with you. So many of us live double lives, let's be honest. And by that I mean the life you create on social media versus your real life. On social media, people tend to post the best aspects of their lives, as you just said. But on the flip side, though, you also have people who post everything to the point that they lack good judgment or discernment as to what is private and that which is for public benefit. And to me, it seems like social media addiction. But then again, I'm not a psychologist. So, Janelle, please tell us, is social media addiction a form of mental illness?
You know, addiction is a mental disorder in the sense that you can be addicted to pornography, you can be addicted to gaming, you can be addicted to alcohol or substance uses and substance abuse. But there's no real category yet per se for social media addiction. That being said, we live in a highly technological society, and I think that going forward, we often use what we call the DSM-5, the Diagnostic and Statistical Manual for Mental Disorders. And I think it's highly possible that things like social media addiction, internet addiction, are going to become written up disorders in our DSM-5, which is really our manual of mental disorders. Psychotherapy would definitely assist with this kind of addiction. But I think also, I think going forward in the future, there's also the possibility of almost rehabs around technology addiction. But psychotherapy is also really intricate in the sense that we look at multiple factors that are affecting somebody and what they may be going through and if that might work or not. The fact that it might be consuming you, though, definitely means that some form of rehab, time out, or psychotherapy and professional assistance would be necessary.
All right, Ashley, let me bring you into the mix here. I did say that with social media, you have those people who just post everything, and some things are private and should be dealt with privately. For example, the video that was doing the rounds on social media, posted by the wife of the local presenter, where she accused him of infecting her with an STD. Clearly, that was something private, which should not have been placed on the public domain, which brings me back to the point that I made earlier about the need for validation or justification through social media, which, frankly speaking, is unhealthy. What are your thoughts?
So, after watching that video regarding Katlego Mabo and his spouse, I think what had happened is in a heat of rage, hell had no fury like a woman scorned. And his spouse didn't actually think about the consequences. She was hurt. She was in a fit of rage and she was hurt. She had no idea how this was gonna hurt her and eventually hurt her son in the long run. I think for her, she was coming from a point of she's wanting to show a point, and the way to get back at Katlego was to do so via social media because of the public figure that he was, or that he is, so rather. The one way to actually impact his life and his career and to hurt him per se was via social media and via his followers. But she didn't actually consider how it's hurting her and her child. So, yes, I would say that we are becoming dependent on social media and also always seeking the opinion of others, constantly, putting on an outfit or whatever we're eating or whatever we're doing, putting it out there so people give you likes or, comments, and whatever they say seems to impact the way you behave and what you put more out there of. I find that people look at the likes and then they determine, okay, you know what, I'm going to do more of this because I'm getting more likes for it. But people forget, is it something that I like to do? Is it something that I want to put out there? It doesn't matter what the viewer feels, So these celebrities as well, I feel like they're not just living for themselves, it's almost as if they're living for society. So it's quite sad, the negative impact that this video has had on the couple, and it's quite unfortunate in the long run for the child. It's very, very sad.
Yeah, and talking about the negative impact of the video that was posted by Katlego's wife, let's talk about the potential for defamation here. Can he argue defamation of character on some level? Altaf, you're also in the legal field. What are your thoughts?
If you look at your requirements for defamation of character, it is infringing on the dignitas or the good personality of a person. You've taken someone who's very much in the public eye, who was quite enjoyable to see on TV, and you've told the entire country that this guy is a cheater, that he is abusive, and that he's given you an STD. What more infringement of the guy's dignitas and personality do we actually require in order to prove that your actions have harmed him?
Well, he's a public figure. What would you say to the argument that celebrities are fair game? They put themselves out there. We can say almost whatever we want to say about them,
I know his name is Katlego, but the outshot in the sky, that's how we all know him. The thing about defamation is it needs to be published. You've taken a video of a private conversation in a private moment, and you've distributed it to whoever, which has now resulted in it going viral across the entire country. To me, that meets the very criteria of publishing. And I honestly think that a defamation of character lawsuit can easily be brought against Katlego's wife.
Okay. I guess, a defense that one could raise is that the information published was for truth and public benefit, meaning that the statements made are truthful and are of legitimate interest to the public. Ashley, yes, I see you have something to add.
Another thing, Elvis, is that the old school way of doing things, back in the day, there wasn't this overflow of social media. Now we have a social media app for every single thing that you can think of. Back in the day, the old school way was counseling. If you had an issue, couples counseling, So I think, in this instance, Datleko's wife, she probably couldn't wait to go for counseling, or she needed like immediate relief. And sometimes we really need to sit back and think about the possible consequences that could arise from our actions. There are possibilities and there are ways, avenues that are opened for court procedures. There are domestic violence, there's protection from harassment. You can get a protection order to keep away from a person that you dislike, or somebody that is harassing you. If you're having marital problems, there is counseling that is available. So yeah, there are other avenues, and we need to think outside of social media.
That is so true, Ashley. That's a very important point you're making there, that we need to find other avenues of airing our issues, such as counseling, be it with your church or professional counseling. And this reminds me of some former Miss SA contestants who had to drop out of the competition as a result of negative and socially unacceptable posts that they had made on social media when they were younger. So you may think it's okay to post something controversial now, but it may just come back to bite you in future, especially for those who are unnecessarily mean on social media. I like to call them thumb thugs. And Janelle, as we wrap up Hot Topics, please give us your final thoughts on this issue of thumb thugs.
Thumb thugs. I think that the actions that these people perpetuate are really a form of cyberbullying, because these people are hidden behind screens, hidden behind personas that they can adopt online. So in a way, they are being cowards, because they're not confronting the situation head on. They're not confronting the problem. It's easy for people to just say what they want when they don't have to wait and get an immediate response from someone else. And I think it is a form of cowardice.
Okay. All right, folks, that's it for Hot Topics tonight. Thanks again to Janelle, Ashley, and Altaf for joining us. Let's take a short musical break, and when we come back, we'll be talking about eviction.
hair pulled back cause the sweat's dripping off of her face. Said it ain't so bad if I wanna make a couple mistakes. You should know right now that I never stay put in one place forever and ever, no more. The midnight sky is the road I'm taking, head high up in the clouds. Oh, I was born to run, I don't belong to anyone. Oh no, I don't need to be loved by you. Fire in my lungs, can't fight the devil on my tongue. Oh no, don't need to be loved by you. See my lips on a mouth, everybody's talking now, baby. Oh, you know it's true, yeah, that I was born to run, I don't belong to anyone. Oh no, don't need to be loved by you, by you. I was born to run, I don't belong to anyone. Oh no, don't need to be loved by you. Fire in my lungs, can't fight the devil on my tongue. You know, don't need to be loved by you. See his hands on my waist, thought you'd never be replaced, baby. Oh, you know it's true, yeah, that I was born to run, I don't belong to anyone. Oh no, don't need to be loved by you, yeah.
All right, welcome back, folks. You're tuned into Capital Radio, and as you already know, the program is Let's Litigate with Alvis. My guest tonight is Devon-based candidate attorney Marine Labashkatni. Hello, Marine. Thank you for being on the show tonight.
Good evening, Alvis, and thank you for inviting me on the show tonight.
All right, tonight we're talking about eviction. And before the break, I posed a few questions, such as, under what circumstances can your landlord start evicting you? Is your landlord legally permitted to turn off the water and lights if you're behind on your rent? All these are questions that people need the answers to, especially if you don't have the privilege of owning your own property and you're renting. And with the way the economy is, along with the high levels of unemployment, the fear of every tenant, as I said, is finding themselves unemployed and being unable to pay their rent. And we often hear horror stories of tenants being forced out of the property that they're renting, or have their property being placed out and the locks getting changed. But what does the law say? Well, there's an act known as the Prevention of Illegal Eviction and Unlawful Occupation of Land Act. It's commonly known as the PI Act, so tonight we'll refer to it as the PI Act. The purpose of this act is to prevent unlawful eviction, to provide for the procedure, a legal procedure, for the eviction of an unlawful occupier, while also recognizing the rights of the owner of the property. So the first thing I want listeners to understand is that in terms of the PI Act, nobody may be evicted from their home without a court order. So that means your landlord can't threaten you by saying that you must leave the premises on or before a certain date. Marine, so we've established that before a person may be evicted, there has to be a court order in place. This obviously means that the matter has to go to court. In brief, what does the process entail?
In terms of Section 4 of the Prevention of Illegal Eviction and Unlawful Occupation of Land Act, the unlawful occupier must be served with a notice of eviction at least 14 days before the date on which the matter will be heard in court. This is important because the unlawful occupier has to be given adequate notice so as to know what the case is about, to be given the opportunity to defend the case, and to obtain legal assistance should need.
Okay, so this notice must contain the date and time on which the matter will be heard in court. along with the grounds on which the eviction is based. So when you say unlawful occupier, Marine, please explain to our listeners what this means.
An unlawful occupier is a person who occupies land without the express or tacit consent of the owner or person in charge, or a person without any other right in law to occupy such land. Examples of unlawful occupiers include squatters or people who are in default of a lease agreement, which is subsequently cancelled by the.
All right, so before starting the eviction process, the landlord will have to give written notice to the occupier, cancelling the right of the occupier to reside on the property and giving him a reasonable period within which to vacate the property. So if the occupier does not vacate the property, then the eviction process, in other words, the court application or notice that Marine spoke about, will commence. So, Marine, in deciding whether to grant the eviction order, what circumstances does the court consider?
In deciding whether to grant the eviction order, the court will consider the duration of occupancy of the unlawful occupier, the defences raised by the unlawful occupier, along with the rights and needs of the elderly, children, disabled persons, and households headed by women. Furthermore, if an order for eviction is granted, the court must also determine a just and equitable date on which the unlawful occupier must vacate the property. And in order to provide for a situation where the unlawful occupier refuses to vacate the property, the court may also set a date upon which an eviction order may be carried out if the unlawful occupier has not vacated the property in question.
All right, and some of you may be wondering, what if the unlawful occupier has set up his structures on the property and still refuses to vacate the property on the date stated by the court? Well, in terms of Section 410 of the PI Act, a court which orders the eviction of any person may also make an order for the demolition and removal of building structures that were occupied by such person on the land in question. Marine, is it possible for the owner of the property, whatever the reason may be, to request the urgent eviction of the unlawful occupier from the property?
Yes, Alvis, in terms of Section 5 of the Prevention of Illegal Eviction Act, the owner or person in charge of land may institute urgent proceedings for the eviction of an unlawful occupier of that land, pending the outcome of the proceedings for a final order. However, the court will not grant such an order unless it is satisfied that there is a real and imminent danger of substantial injury or damage to any person or property if the unlawful occupier is not evicted from the land. Furthermore, the court will not grant an order for urgent eviction if it's shown that there is likely hardship on the owner or any other affected person if an order of eviction is not granted, or if shown that there is no other remedy available.
Okay, so as I said before, unless you have a court order, you can't evict a person from your property. If you do, you'll be guilty of an offense and liable on conviction to a fine or imprisonment of 2 years, or both a fine and imprisonment. So Marine, besides the PI Act, is there any other way for the owner to evict the occupier? And I'm asking this because if there's somebody listening right now who owns property, and they want to know what other way is there to evict an unlawful occupier.
No, Alice, the Prevention of Illegal Eviction Act informs us in Section 4, subsection 1, that notwithstanding anything to the contrary contained in any other law or the common law, the eviction of an unlawful occupier shall be effected in terms of the PI Act. This means that the owner of the property cannot take the law in his own hands by changing the locks or turning off water and lights. If this happens, as you said earlier, Elvis, the owner will be guilty of an offence and liable on conviction to a fine or imprisonment.
All right. I must also state that if you, being the unlawful occupier, fails to attend court or to defend your case, then you run the risk of the court granting the eviction order in your absence. And what are your rights in this process? Well, as I said, you have to be served with the eviction notice 14 days before the date on which the matter will be heard, and you have the right to apply for legal aid should this be required. All right, let's take a short break now, and when we return, we'll be asking the question, does your landlord have the right to enter your premises if and when he so wishes in order to inspect the place? And to take us to the break is a classic, Simply Red, Something Got Me Started.
Something got me started. You know that I will love you. Lately since we parted, I truly know that I need you. I give it all up for 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 you. Yes, 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 I would. Totally broken hearted, guilty of what I did to you. Lately since we parted, I truly know that I need you. Yes, I do, because I give it all up for you. 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 Yes, 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 I would. I really love you. Come on, I give it all up for you. 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 Yes, 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 I would. Yes, I would. Yes, I would. Yes, I would. Hey, yeah. Yes, I would.
All right, welcome back to the show that discusses legal matters in a simple and straightforward manner to educate you, yet also entertaining you at the same time. My guest tonight is Marine Labashkakni. She's a candidate attorney at a Durban-based law firm, and before the break, we were talking about unlawful evictions. And we ascertained that without a court order, your landlord cannot evict you. And there's no question of you being denied the right to water and electricity either. Let's now talk about the Rental Housing Act and see what it says about the landlord's rights, tenants' rights, and the deposit that is paid when you decide to rent a piece of property. Marine, what would you say to somebody who says that their landlord has a habit of just entering the rented premises without prior notice and does so in the absence of the tenant?
Even this aspect of the landlord-tenant relationship is legislated in terms of Section 4, subsection 2 of the Rental Housing Act. The tenant has a right during the lease period to privacy, and the landlord may exercise his right to inspection of the property in a reasonable manner and after reasonable notice to the tenant. Furthermore, the tenant's rights include his right not to have his home or property searched and to the privacy of his communications.
All right, thank you for clearing that up for our listeners. And if you're a landlord, remember, you heard it on Let's Litigate, your tenant has a right to privacy. So just because you own property doesn't give you the right to just enter the premises as and when you please, or to do an inspection of the property, or to do renovations without prior notice to the tenant. And you know, Marine, since you brought up the Rental Housing Act, let's talk about that act because it contains a lot of important information pertaining to the relationship between the tenant and the landlord. For example, when it comes to advertising or leasing the property, a landlord is not allowed to discriminate against the tenant or the tenant's visitors on the grounds of race, gender, pregnancy, marital status, religion, the list goes on. So your landlord can't say that you're not allowed to have certain visitors just because those visitors are of a certain race, religion. And Marine, let's start at the beginning. What does the Rental Housing Act tell us about the deposit that is paid by the tenant? I mean, does a deposit always have to be paid? And once it's paid, where does this go?
The Rental Housing Act, as amended, informs us that a deposit may be required by the landlord, so it is possible for the premises to be rented out without a deposit. So once paid, this deposit, in terms of Section 4, capital B, must be invested by the landlord in an interest-bearing account with a financial institution and must be repaid to the tenant together with any interest accrued on the amount when the lease expires. And I must add that the deposit may not exceed an amount equivalent to the amount specified in the lease agreement or otherwise agreed by the party.
Wow. You know, and still talking about the deposit paid by the tenant, you just said that this amount must be invested in an interest-bearing account. Legally speaking, then, who does this money belong to? You know, is the tenant permitted to inquire as to the interest that has accrued on this amount? And what if the landlord passes away? Does this deposit form part of his estate?
Elvis, those are very good questions. Let me start by saying this. The tenant is permitted during the lease period to request from the landlord written proof of the interest that has accrued on the deposit paid, and the landlord must, in terms of Section 4, capital B, subsection 2 of the Rental Housing Act, as amended, provide this information. Then with regards to your question as to who does this money belong to, and does it form part of the estate of the landlord should he pass away, in terms of Section 4, capital B, subsection 1, the deposit, along with the interest accrued, shall not form part of the assets of the insolvent or the deceased estate of the landlord in the event of his death or insolvency.
Wow, you know, this is indeed valuable information to the listeners out there. I mean, did you know that your rental deposit has to be put in an interest-bearing account and that you have the right to know how much interest has accrued on this amount? Well, you tuned into the right show that'll give you the legal scoop. So if you decide to move out, the landlord has to pay you back your deposit along with the interest that is accrued on this amount. And in the event that no property was to the reasonable cost of repairing the damage to the property, and the balance of this must be paid back to you within 14 days as stated in the Rental Housing Act. And then in the event that you require proof of the costs incurred by the landlord in repairing the damage to the property, guess what? You're also entitled to this. That's what the law says. Marine, let's now talk about what happens when the tenant moves into the premises. My advice is the landlord and the tenant should both inspect the premises. That way, when the tenant subsequently moves out, there's no confusion as to what is normal wear and tear versus what was actually damaged by the tenant and what should be deducted from the deposit. What does the law tell us?
Elvis, your advice is correct. In terms of Section 4, capital B, subsection 4 and subsection 5, the tenant and the landlord must, and bear in mind I said must, jointly before the tenant moves into the premises, inspect the premises in order to ascertain the existence of any defects or damage. That way it's clear that same wasn't caused by the tenant and the cost of repair won't be deducted from his deposit. And when the lease expires, the parties must arrange a joint inspection within 3 days prior to the expiration of the lease in order to establish the extent of the damage to the premises during the tenant's occupancy.
All right, I must also add that in the event that the tenant vacates the premises before the lease expires and without notice to the landlord, the lease is deemed to have expired on the day that the landlord discovers that the tenant has vacated the premises, and the tenant will be deemed to have breached the contract, which means that the landlord retains all his or her rights arising from such contract. And Marine, legally speaking, can the landlord inspect the premises during the lease period?
Yes, the landlord is indeed legally permitted to inspect the premises during the course of the lease. However, as stated in Section 4, capital B, subsection 8, the landlord must still respect the tenant's right to privacy during the lease period and may only exercise this right in a reasonable manner and after giving reasonable notice to the tenant. I must also add that, as stated in Section 4, capital B, subsection 11, the landlord must provide the tenant with a dwelling that is in habitable condition as well as to maintain the existing structure of the dwelling. Therefore, there is no merit in argument that the tenant is expected to repair the damage that occur as a result of normal wear and tear to the premises.
All right. And to landlords listening out there and wondering what it means to say that the dwelling must be in a habitable condition. This means that the dwelling must be safe and suitable for living, meaning that it has adequate space, protection from the elements and other threats to health, physical safety of the tenant and the tenant's household visitors. And finally, the actual building must be structurally sound. Let's talk now about the monthly rental that is paid. In particular, when you pay your rent, are you entitled to receive a receipt? And what information should that receipt contain? Marine, please tell us.
In terms of Section 4, capital A, the tenant has the right to receive a written receipt from the landlord for all the payments he made to the landlord. The receipt must be dated and contain the address for the dwelling in respect of which the payment is being made, and it must also indicate whether the payment was made for rental, arrears, or deposit, along with the period for which the payment is made. Furthermore, when it comes to subletting, the tenant may not sublet the premises without the written consent of the landlord.
Okay, let's now talk about, well, let's focus on the landlord and talk about his rights. Please elaborate further in terms of the Rental Housing Act.
Well, the landlord has a right to prompt and regular payments of the rent or any other charges payable in terms of the lease, such as utility bills or contributions to the utilities or municipal accounts. So that means that you cannot pay your rent whenever you please or delay the payment. The landlord has also a right to recover the unpaid rental or any other amount that is due and payable. Furthermore, upon expiry of the lease, the landlord has a right to receive the rental housing property in a good state of repair, except for the fair wear and tear of the property.
All right, as we said before, in the event that the tenant fails or refuses to vacate the property, the landlord may evict the tenant from the premises after obtaining a court order and may claim compensation for damage to the property if said damage was caused by the tenant or a member of the tenant's household or a visitor of the tenant. What about the lease agreement? Marine, is it a legal requirement to have one? And what should be contained in the lease agreement?
In terms of the Rental Housing Act, it's a must of it for there to be a lease agreement and must be reduced to writing. The lease must contain pertinent information such as the names of the landlord and the tenant, a description of the premises, the rental paid, the frequency of the rental payments if the rental payments are not paid monthly. The lease must also specify the deposit being paid along with the period of the lease. And in case somebody out there was wondering as to whether the tenant can make alterations to the property, the lease would also have a clause that prohibits this, unless, of course, if the landlord consents to such alterations to the
All right, so some of you may also be wondering, what if the property is sold? Well, the tenant still has the right to stay on the property until the lease expires, provided that he's not in breach of the lease in some form. All right, folks, let's take a short break now, and when we return, we'll be dealing with the aspect of where does the landlord or the tenant go if they have a dispute.
She was a Jezebel, this Brixton queen, living a life like a backstreet dream, telling my lies when the truth was clear. I think she knew what I wanted to hear, spinning around like a wheel on fire, walking on tightrope and love's highway. Fatal attraction is where I'm at, there's no escaping me. I just wanna be close to you, and do all the things you want me to. I just wanna be close to you and show you the way I feel. I feel love when I'm lying in the midnight hour, holding you just like a dream. Love is never what it seems when we're touched, and you're holding me the way you do. Girl, you make my dreams come true. You make my dreams come true. I just wanna be close to you and do all the things you want me to. I just wanna be close to you and show you the way I feel. She was a Gemini on the cusp of Mars. She holds me back or she goes too far, winding me up just to let me down. So emotional, gagged and bound. There's more to this than meets the eye. A devil woman locked inside. With the full moon rising, I was scared. I think I was possessed. time your body's next to mine. Something deep inside of me wants to love you endlessly. When you touch, girl, you don't know how it makes me feel. I just can't believe it's real. I can't believe it's real. I just wanna be close to you. Do all the things you want me to. I just wanna be close to you and show you the way I feel. She had an attitude I can't explain. You never know if you're in frame. Tying me up with elastic words. I'm on a countdown till I get hurt. Her blood was hot, she burned so bright. A neon sign there in the night. It's hard to say if I went too far. My heart still bears a scar. I just wanna be close to you. I just wanna be close to you. I just wanna be close to you. Living a life like a backstreet dream. Telling the lies when the truth is clear. I think you knew what I wanted to hear. Spinning around like a wheel on fire. Walking on tightrope and love's highway. The fatal attraction is where I'm at. There's no escaping me. I wanna be close to you. Do all the things you want me to. I just wanna be close. I just wanna be close to you, baby. And show you the way I feel. I just wanna be close to you, baby. Do all the things you want me to. I just wanna be.
All right, welcome back to the final segment of Let's Litigate with Elvis. As I already said, my guest tonight is Marinela Bashkakni. She's a candidate attorney at a Durban-based law firm, and we're talking all things to do with landlords and tenants. Before the break, we established that it's okay for the tenant to sublet the premises as long as he has the consent of the landlord to do so. Let's now talk about the issue of where does one go when a landlord and tenant dispute comes up. Well, besides taking legal action in a court of law, the Rental Housing Tribunal is available and its services are free. It provides information and advice to tenants and landlords with regards to their rights and obligations. In terms of Section 7 of the Rental Housing Act, the Rental Housing Tribunal was established to resolve disputes between tenants and landlords arising out of unfair practices in residential dwellings, be it flats, privately owned houses, shacks, communes, backyard rooms, the list goes on. Marine, I've just stated that the Rental Housing Tribunal resolves disputes between landlords and tenants arising out of unfair practices in residential dwellings. Please explain this term to our listeners.
When we say unfair practices in respect of dwellings, we are talking about an act or an omission by the landlord or tenant that is in contravention of the Rental Housing Act, or an act that unreasonably infringes on the rights or interest of a tenant or a landlord, such as the non-payment of rent, damages to the property, eviction, nuisance, intimidation, overcrowding, and the list goes on.
All right, and in case you're wondering, who may lodge a complaint with the Rental Housing Tribunal? Well, the list is endless. Tenants, landlords, body corporates, tenants associations, property managing agents. And how is a complaint lodged? All right, so the complaint to the tribunal must be in writing, and normally the tribunal will provide you with the complaint form, which you may submit by mail or in person. So, Marinette, please elaborate further as to what are the powers and functions of the tribunal. I've already stated that it receives complaints lodged by the tenants and landlords.
In terms of the Rental Housing Act and the relevant regulations, the Rental Housing Tribunal is vested with rights and obligations to conduct mediation and hearings in order to resolve the disputes that have been lodged. This may also include the referral of a matter for further investigation if it appears that a contravention has taken place. Then, when it comes to unfair practices, the tribunal may also make a ruling for a person to comply with a provision of regulations relating to unfair practices. Ultimately, the tribunal has to make a ruling that is just and fair so as to terminate any unfair practice, such as a ruling to discontinue exploitative rentals, unacceptable living conditions, overcrowding, and lack of maintenance.
All right, and other services provided by the Rental Housing Tribunal include an investigation of complaints, resolution of disputes through mediation or hearings, as Marinette just said, and giving general advice and information with regards to lease agreements. Marinette, what would you say is the advantage of using the Rental Housing Tribunal as opposed to the Magistrates Court?
Always, as you already said, the services of the Rental Housing Tribunal are free. The complainant won't need the services of an attorney as opposed to instituting legal action in the magistrate court. Furthermore, the very fact that you may lodge a complaint via email or ordinary mail provides ease of access to this forum and speedy resolution of the dispute. Section 13 of the Rental Housing Act also informs us that when unfair practice exists and the tribunal makes a ruling, such ruling is deemed to be an order of the magistrate court.
All right, and folks, thank you for joining us tonight. That's it for the show. I hope you feel enlightened because that's why I do the show, to inform you, to educate you, and to place you in a situation where you can step out confidently into the world and assert your rights because knowledge is power. Marinette, thank you so much for joining us tonight and sharing your knowledge with our listeners.
It's a pleasure, Alvis. Thanks for inviting me on the show tonight.
All right, folks, remember to send us your requests as to what topics you'd like covered in future episodes. The WhatsApp line is 065 4211 380. I'll repeat that, 065 4211 380. I can't wait to hear from you. So until next Tuesday, this is Elvis signing off.
Let's litigate with Elvis. Tuesdays, 7 to 8 p.m. on Capital 88.1 FM.
Carry on my wayward son. There'll be peace when you are done. Lay your weary head to rest. Don't you cry no more.